Okay, welcome back to the deep dive. I'm your host. Today we're getting into something really fundamental about contracts. It's it's about what happens when a deal goes south. And one side doesn't follow through on their promise of breach. So what can the person who's been let down actually do? We're talking remedies today. How does the law step in?
Exactly. And it's crucial because without remedies, a contract isn't much more than just wishful thinking, is it?
True. So our mission here is to use the materials we have to really explore these different legal tools. We'll look at the usual ways courts try to compensate, like getting paid back, but also some more unusual court orders. And importantly, we'll work through a scenario from the materials to see how you'd actually use these ideas in practice. Think of it as like building your contract first aid kit.
A good way to put it.
Yeah.
So first off, what is a breach? The materials say it happens whenever a contract term isn't performed, well, precisely as agreed, any deviation, technically, and when that happens, the law provides remedies for the innocent party. The materials split these into two main camps you can pursue through the courts: common law remedies and equitable remedies.
Okay. Common law and equitable. What's the key difference there?
It's a big one. Common law remedies, especially damages, which is getting money, are generally available as of right, meaning if you prove your case, prove the breach caused a loss, you're entitled to them. The court doesn't really have a choice.
Ah, okay. Like a default setting.
Sort of, yes.
Yeah.
But equitable remedies,
Mm-hmm.
they're different. They're discretionary. The court weighs things up. Is it fair? Is it practical? They decide whether to grant them or not. It's not automatic.
Got it. So common law is the standard toolkit. Equitable is more like the specialist equipment. Let's start with the standard, then damages. That's the main common law one, right?
Definitely the most common. Damages are just monetary compensation, money paid by the party who breached to the injured party.
But it's not about punishment, is it? That's key.
Absolutely not. The purpose, as the materials stress, is to put the injured party back in the financial position they would have been in if the contract had actually been performed properly.
So you're trying to like financially recreate the success of the contract.
Precisely. You're compensating for the lost expectation. And when courts are figuring out how much money that is, the materials point to three really critical factors they consider:
What are they?
causation, remoteness, and mitigation. You generally need to satisfy all three.
Right. Causation, remoteness, mitigation. Let's break those down. Causation first.
Causation. Simple idea, sometimes tricky in practice. You have to show that the breach actually caused the loss you're claiming. There needs to be a link.
How do they test that link?
The standard test mentioned in the materials is the but-for test, you ask. But
Yeah.
for the defendant's breach of contract, would the claimant have suffered this loss? If the answer is no, the loss wouldn't happen without the breach, then causation is usually established.
Seems straightforward enough, but for the breach, no loss.
Okay, it often is.
Yeah.
But complications can arise if there are multiple causes. But let's move to the next hurdle.
Remoteness. Now, this is where it gets interesting, isn't it? Because not every loss that's caused by a breach can actually be claimed.
Exactly. The law draws a line. Otherwise, liability could stretch on forever, covering completely unexpected knock-on effects. Remoteness prevents that. It limits claims to foreseeable consequences.
And the big case here, the one everyone learns, is Hadley and Baxendale.
That's the one. Hadley and Baxendale, a foundational case from the 1850s. The facts, briefly. A mill owner's crankshaft broke, stopping the mill. They hired a carrier, Baxendale, to take the broken shaft to be used as a template for a new one.
Okay.
Baxendale's delivery was delayed. Because of the delay, the mill was stopped for longer than expected,
Yeah.
and the owner, Hadley, sued for the profits lost during that extra downtime.
Makes sense. The delay caused the lost profits, but
But the court said no. Those lost profits were too remote. And they laid out this crucial two-part test for what is recoverable. First, you can recover losses that arise naturally, according to the usual course of things, from the breach, things you'd normally expect.
okay. Standard consequences.
Second, you can recover losses that might be unusual or exceptional, but only if they arise from special circumstances that were communicated to the other party, or reasonably supposed to be known by them at the time the contract was made.
So it's about what both sides could reasonably foresee when they shook hands, essentially.
Precisely. And in Hadley's case, the carrier, Baxendale, didn't know the mill was completely stopped waiting for this one shaft. For all they knew, Hadley might have had a spare.
So losing all profit wasn't a natural consequence of a shaft delivery delay.
Correct. And the special circumstance, the idle mill, wasn't communicated. So it wasn't in Baxendale's reasonable contemplation. Loss denied.
That case really sets the stage. Did later cases tweak this?
They refined it, yes. They focus more on this idea of reasonable contemplation and foreseeability at the time of contracting. Take Kufos and Zarnikau, often called the Heron II. A ship was hired to carry sugar to Basra. It was delayed by about 9 days.
Okay.
In those 9 days, the market price for sugar in Basra fell. The charterer lost money because they got less for their sugar.
So similar to Hadley lost profits due to delay.
Yes, but the outcome was different. The court said the loss was recoverable. Why? The ship owner knew he was carrying sugar, knew there was a market for it in Basra, and should have reasonably contemplated that a delay could cause the price to change and the charterer to lose money. It was considered a foreseeable type of loss in that context.
So the type of cargo and its destination mattered. What about Victoria Laundry and Newman Industries?
Another key one. Victoria Laundry ordered a large boiler from Newman Industries for their laundry and dyeing business. Delivery was 5 months late.
5 months. Ouch.
Indeed. Victoria Laundry claimed for 2 things. First, the normal profit they lost from not having the bigger boiler capacity during those months. Second, they claimed for losing out on some very profitable specific dyeing contracts they could have taken on with the new boiler, including a government contract.
And the result?
The court allowed the claim for the normal lost profits. Newman Industries knew they were supplying a boiler to a laundry. It was reasonably foreseeable that delaying delivery would cause loss of normal business profit.
But not the special contracts.
No. Newman Industries had no idea about those specific, highly lucrative dyeing contracts. That loss wasn't in their reasonable contemplation when they agreed to supply the boiler. It was too remote, like the extra profits in Hadley.
Okay, so it really hinges on what the breaching party knew or should have known about the potential consequences when the deal was made.
Exactly. That's the core of remoteness, what was reasonably foreseeable to both parties.
Right. That leads us to the third factor, mitigation. What's this about?
Mitigation means the injured party. The claimant can't just sit back and let their losses mount up after a breach. They have a duty to take reasonable steps to minimize their loss.
So you have to try and limit the damage.
Yes. If you fail to take reasonable steps you could have taken, your damages award will be reduced by the amount you could have saved.
Who has to prove you failed?
The defendant, the party who breached. They have the burden of showing the claimant didn't act reasonably to mitigate the loss.
Is there a classic example?
The materials mention Brace and Calder. An employee was part of a partnership that dissolved, technically ending his employment contract. But 2 of the former partners immediately offered him identical employment in their continuing business. He refused it.
Why?
Well, he sued for lost wages for the rest of his original contract term. But the court said, look, you were offered a perfectly reasonable alternative job straight away. By refusing it, you failed to mitigate your loss. His damages were reduced significantly, basically to nothing, because he could have avoided the loss entirely.
Makes sense. You can't unreasonably refuse to stem the bleeding, so to speak.
That's the idea.
Okay, so damages are the main common law remedy, governed by causation, remoteness, and mitigation. Any others at common law?
The materials briefly mention quantum eruit.
Latin again, what's that?
It means as much as he has earned. It's not really damages for loss of a bargain. It's more about getting paid a reasonable sum for work you've actually done.
When would you use that instead of damages?
Sometimes it's an alternative. If, say, a contract is found to be void, or if one party stops performance after the other has already done part of the work. The case often cited is Planch and Colburn. An author was contracted to write a volume for a series called The Juvenile Library.
Okay.
He did a lot of the writing, but then the publisher canceled the whole series. He couldn't finish the book as contracted. He couldn't sue for the full contract price because he hadn't finished. But the court allowed him to claim on a quantum eruit basis a reasonable amount for the work he had completed before the project was abandoned.
Got it. Payment for work done when the contract goes sideways.
Essentially, yes.
All right, that covers the common law side. Now, what about those equitable remedies? The discretionary ones?
Right, the ones the court grants only if it thinks it's fair and just in the circumstances. 2 main ones are discussed: specific performance and injunction.
Specific performance sounds like it means making someone actually do what they promised.
Exactly that. It's a court order compelling the breaching party to perform their positive obligations under the contract, to actually do the thing they agreed to do.
But you said it's discretionary. When would a court order this?
Typically, only when damages money would be an inadequate remedy.
What makes money inadequate?
usually because the subject matter of the contract is unique or special in some way. The classic examples in the materials are contracts for the sale of land, because each piece of land is unique, or maybe for rare antiques, unique works of art, or sometimes shares in a private company that you can't just buy on the open market. Things money can't easily replace.
So, not for everyday goods you could just buy elsewhere.
Generally not. And there are other bars too. Courts won't grant it if damages are adequate, if it would require constant supervision by the court, like forcing someone to run a business.
That'd be impractical.
Right. Or if the contract is for personal services, like forcing an employee to work or an employer to hire someone. Courts don't like compelling personal relationships. Also not usually for contracts involving minors or contracts to simply lend money.
Okay, so specific performance forces you to do something positive. What about injunctions?
An injunction is usually about stopping someone from doing something. It enforces a negative promise in the contract.
Like a thou shalt not clause.
Precisely. Think of things like restraint of trade clauses, promising not to compete after leaving a job, or exclusivity clauses, promising only to work for one party.
And when are these granted? Same reason as specific performance.
Yes, generally when damages would be inadequate compensation for the breach of that negative promise. The materials give the example of Warner Bros. Pictures, Inc. and Nelson.
The Bette Davis case.
That's the one. Bette Davis, Nilsson was her real name relevant to the case, had a contract saying she'd work exclusively for Warner Bros. And wouldn't work for any other film studio.
And she wanted to.
She planned to work for another studio in breach of that promise. Warner Bros. Sued for an injunction to stop her.
Did they get it?
Yes, the court granted the injunction to prevent her working for the rival studio. They reasoned that her acting talent was unique, and just paying Warner Bros. Damages wouldn't properly compensate them for losing her exclusive services during the contract period. Money wasn't enough.
Interesting. So equitable remedies are powerful, but used carefully for specific situations where money just doesn't fix the problem.
That's a good summary.
Okay, this is great. We've got the tools, damages, causation, remoteness, mitigation, quantum meruit, specific performance injunctions. Now let's put it all together. How do you apply this stuff? The materials have a hypothetical, right?
Yes, a practical scenario to test our understanding. And they suggest using a structure: issue, rule, application, conclusion, often called IRWAC. It's a standard way to approach legal problem questions.
Excellent. Let's hear the scenario.
Okay, imagine a farmer. They contract with a delivery company to ship some special, let's say, time-sensitive vegetable seeds to a buyer. They need to arrive by a specific date for the planting season.
A critical deadline.
Very critical. But the delivery company is delayed by a week.
Oh, dear.
Because of that 1-week delay, the buyer misses the narrow planting window for these seeds entirely. The whole potential crop for that season is lost.
Wow, big loss from a 1-week delay.
So the question is, can the farmer sue the delivery company and recover the full value of that lost crop?
And there's a twist, isn't there?
Yes. Does it change things if the farmer specifically told the delivery company, when they made the contract, just how crucial that delivery date was for planting and the risk of losing the crop?
Okay, great scenario. Let's use that IR restructure first. Issue. What's the legal question here?
The core issue is about the extent of the delivery company's liability. Are they responsible for the value of the entire lost crop? More specifically, focusing on damages, is that loss too remote? And flowing from that, what's the legal effect of the farmer giving specific notice versus just sending the seeds?
Right. Okay, step 2. Rule. What legal principles apply?
Well, we know the primary remedy is damages, aiming to put the farmer in the position they expected having a successful delivery. We need to consider causation, the but-for test. Did the delay cause the loss? And crucially, remoteness the rule from Hadley and Baxendale. Are the lost crop profits a natural loss or an exceptional loss arising from special circumstances? And were those circumstances within the reasonable contemplation of both parties at the time of contract? We need to think about the Heron II and Victoria Laundry here too.
Got the rules. Now, application linking the rules to the facts. This is the meaty part. Let's start with causation.
Okay, causation. But for the delivery company's 1-week delay, would the crop have been lost?
Seems clear, no. The delay directly caused the misplanting window, which caused the lost crop. So causation looks pretty solid.
Agreed. Causation is likely established. Now the trickier one, remoteness. Let's take scenario 1 first. The farmer just shipped special seeds with a deadline, but didn't explain why the deadline was so critical.
Right. No specific warning about losing the whole crop.
So, under Hadley and Baxendale, is losing the entire crop value from a 1 week seed delay a normal loss, one that arises naturally in the usual course of things?
Maybe not. Delay might cause some inconvenience, maybe needing to buy slightly different seeds, but losing the whole season's profit seems quite extreme for a standard delivery contract. It feels more exceptional.
I tend to agree. It likely falls under the second limb exceptional loss. So the question becomes, was this exceptional loss within the reasonable contemplation of the delivery company, given what they knew when they took the booking?
They knew they were delivering seeds and they knew the date, but did they know a 1 week delay meant total crop failure? Probably not, unless seeds always work that way, which seems unlikely.
Exactly. It's like Hadley's mill shaft or Victoria Laundry's lucrative government contract. Without being told about the critical narrow planting window and the potential for complete loss, the delivery company could argue they couldn't reasonably foresee such a drastic outcome just from delivering seeds a week late. It's arguably too remote.
Okay, so in scenario one, probably no recovery for the full crop value. Now, scenario two. The farmer specifically warns the delivery company. These seeds must arrive by this date, or the planting window closes and the whole crop is gone.
Now this changes the knowledge factor significantly. The farmer has communicated the special circumstances and the specific risk involved.
So applying the second limb of Hadley and Baxendale, was the loss total crop failure within the delivery company's reasonable contemplation at the time of contract, given this explicit warning?
Now, arguably, yes, they were put on notice. They knew the consequence of delay wasn't just inconvenience, but potentially catastrophic loss for the farmer. By accepting the contract under those terms, they arguably accepted the foreseeable risk.
It's like the Hare and the Second, the ship owner knew about the sugar market. Here, the delivery company knows about the planting window market, so to speak.
A good analogy. Or like Victoria Laundry, if they had known about the government contract, the outcome might have been different. Here, the delivery company does know about the critical nature. So the loss, while large, arises from special circumstances that were expressly made known.
Okay, that application seems clear. So, final step, conclusion. What's the likely outcome in each scenario?
Based on our application. In scenario 1, no specific warning. The claim for the full value of the lost crop would likely fail on the grounds of remoteness. It wasn't a natural loss, and the exceptional consequence wasn't reasonably contemplated because the special circumstances weren't communicated.
So the farmer might get something for the delay itself, maybe the cost of the seeds, but not the lost profit.
Possibly, yes, depending on what was foreseeable, but likely not the full crop value. However, in scenario 2, at the specific warning, the farmer's claim for the lost crop value has a much stronger chance of success. The communication of the special circumstances brought that potential loss within the delivery company's reasonable contemplation at the time of contracting. Therefore, the loss is likely not too remote.
Wow. So that one piece of communication makes all the difference legally.
It often does in contract law, especially concerning damages. What you know or should know up front is key.
Okay, let's recap this deep dive then. We looked at what a breach is. We saw the difference between common law remedies like damages available as of right and equitable remedies, which are discretionary. We really dug into common law damages, their purpose, compensation, not punishment, and those three hurdles, causation, but for, remoteness, the two limbs of Hadley and Baxendale refined by cases like the Hare and the Second and Victoria Laundry, and mitigation, the duty to take reasonable steps like Embrace and Calder.
And we touched on quantum erud as much as earned with Planch and Colburn.
Then we switched to equitable remedies. Specific performance, making someone do something used for unique items when damages are inadequate, and injunctions, stopping someone doing something, like in Warner Bros. And Nelson. Remember, they're always at the court's discretion.
And crucially, we use that hypothetical farmer scenario to walk through the IRSC method issue, rule, application, conclusion, showing how you apply these principles step by step.
Yeah, and seeing how that single act of telling the delivery company about the planting window potentially changed the outcome under remoteness, that really drives home the practical importance of clear communication in contracts, doesn't it?
Absolutely. It highlights how managing expectations and potential risks before things go wrong is so vital.
Which leads to a final thought. If parties were always completely transparent about all the potential significant risks involved when they make the contract, could that, theoretically, eliminate the need for courts to grapple with remoteness after a breach has already happened? Or is there always going to be some unforeseen element? What stands out most to you from our discussion today?